Okay, we're a couple of minutes past the hour. I think there's a few more people due to come through, but we'll make a start, given the time. And welcome everyone to this IUA market briefing um, on the seafarers' rights and the UK Seafarers Charter. It's been I guess, an ever more difficult time for seafarers, both in the geopolitical sense, but equally looking at some of the employment rights we've seen, particularly around, I suppose, driven by the P&O Ferries case. And we thought it would be useful to get a more in-depth steer on what the UK Seafarers Charter is, what it means, how it applies, and what we may see as next steps in the future. So to help us with that, I'm delighted to welcome Mark Hamilton, who's a partner at Denton's, and has done a lot of work around this area. Mark's going to give the presentation on all the issues I've mentioned, and is happy to take questions during the session, but we can obviously pick up some questions also at the end. If you want to submit questions, you can use the Q&A function, which is in Zoom, the platform we're using in the normal way, and I will join post presentation and we'll moderate some of those. We are recording this session, and we'll make this available, I think, post session on our website, and we will also share the slides that Mark has helpfully put together for us. So let's progress on that basis. Mark, over to you. I think you've got access to the slides, and I'll leave that with you, and I'll chip in due course.
Thank you very much, Chris, and thank you everybody for inviting me to talk to you about the Seafarers Charter, and hopefully talk with you at some point during today's session. As Chris has said, the idea is to talk about the Seafarers Charter and consider the rights it creates, and in particular, the new legal obligations underlying those rights and what it seeks to achieve. So I'm hoping that you can see those slides and that they will advance when I try to advance them. Is that working? Okay, no, it's not working the quick way, so let's do the old way. So what are the goals of the Charter? And before looking at those in detail, it's worth just reminding ourselves of why we're here, why have we got a Seafarers Charter? And as Chris says, it really all flows from the P&O redundancies in 2022. Already seems quite a long time ago. Whereas you'll remember, P&O made about 800 seafarers redundant pretty much overnight and didn't go through the consultation requirements, which did apply and which P&O later accepted should have been followed. And they simply made a commercial decision to ignore those requirements and to proceed straight to the redundancies. That inevitably led to a degree of controversy and lots of questions in Parliament and all those sort of things. So the idea then became to see what could be done for two, I think, particular goals. One is to protect seafarers' rights within the UK. And by that, they don't just mean UK seafarers, they mean seafarers operating within UK territorial waters. But also to essentially seek to protect not just the employment rights of the UK, of those seafarers, but the economic opportunity to continue using UK resident seafarers by making it more difficult to employ non-UK resident seafarers and perhaps undercut the UK employment rights. So it's definitely different aspects to the Charter. The immediate result was a 9-point plan, and that then has morphed into the Seafarers Charter, and in particular a certain amount of statutory employment protection rights. And we'll look at all those in a second. But fundamentally, the Charter itself is a voluntary arrangement intended to establish high standards for seafarers' working conditions and welfare, at least insofar as those seafarers' work touches the UK. That's the way it has been described. So it is, and it's an important change. I think. And the idea again is that it is flag and nationality blind. It doesn't depend on the residency or the home port of the crew. It'll depend on whether they are operating in the UK. Right. So the first step after the P&O matter was to introduce the what it was called the 9-point policy paper. Now, this is not the charter. The charter already also has 9 points, and there can sometimes be a bit of confusion between the two. But the policy from 2022, in the immediate aftermath of the P&O redundancies, was introduced this, say, 9 points. One was to ensure that the at least the equivalent of the UK national minimum wage was introduced paid to all seafarers operating within the UK. The second was enforcing that by suspending access to ferry operators, but to services, marine services who did not pay the UK minimum wage, suspending their access to UK ports. The third point is working together with international partners to try and enforce these rights by making it so not just having a unique regime in the UK, which made the UK unattractive, but to have a working arrangements with other international organizations, international countries, where the protections would apply at both ends of the journey. They would also, the plan was to have HMRC dedicate resource to enforcing the UK minimum wage in the maritime sector. Now, those who deal with the HMRC may question whether it has the resources to do much of that, but certainly that's the objective here. They also want the MCA, the Maritime and Coast Guard Agency, to continue their robust enforcement policies. Perhaps let you tell me whether those are robust enforcement policies at the moment, from your perspective. Developing a statutory fire and rehire code. Now, that is something the government has done. It has published that code. It doesn't just apply to the maritime sector, it applies to the whole of the UK employment sector. And essentially, what it does is discourage employers from firing their workforce in order to introduce changes and then offering them re-employment on new contracts. This is the fire and rehire. And it makes it a little bit more difficult to do that than it was prior to the introduction of the code. It increases the likelihood that such measures will be considered to be unfair dismissals. But in order to bring an unfair dismissal, the worker has to be essentially working primarily within the UK. So that may have less impact on some maritime workers, some seafarers. The government want to take action against company leaders who break the law. Now, we haven't seen specific action on that as yet, but that's certainly the direction of travel. They want to improve long-term working conditions, and the Charter certainly seeks to address that. And the final point of the 9-point plan was to encourage more ships to operate under the UK flag. As I say, there's an economic element to these measures, not just the employment protection. So I think it will be interesting, and I would be interested to hear your views on whether you think the Charter and the rights which have been introduced do actually achieve these policy objectives. Because some people might well consider the degree of inconsistency between those objectives. But anyway, let's look in a little bit more detail then at the Charter. The Charter came out about a year later. It also has 9 points in it. It's important to remember that the Charter is essentially a voluntary arrangement. The one exception to that is the Seafarers Wages Act, which is the measure to enforce national minimum wage, and which we'll come on to in a second. It is aimed at covering the vessels which are covered by the Seafarers Wages Act. And again, I'll talk about that in a minute. The way the Charter works, as you may well be aware, is that it is essentially a badge, a certification from the Department for Transport that a seafarer is operating to approved standards, the standards set out in the charter. And operators of vessels will be able to apply for Verified Seafarers Charter status. Or if they haven't quite achieved that yet, they'll be able to apply for a progressing towards Verified Seafarers Charter status if they're expecting to be able to comply within the next 12 months or so. Much will, because it's voluntary, inevitably a lot will depend upon whether customers of shipper operators decide to make charter status a contractual requirement, or at least an important factor in deciding which operators they contract with. And I suppose it may also be important as to whether underwriters decide to make seafarers charter status an important factor in setting premiums for insurance. That would obviously play a big part in getting operators to comply with the charter and seek verification of their compliance. So, looking broadly at the charter, then its aims is to ensure that the fundamental rights of seafarers are protected. One of those is fair wages, another is rest periods, and a third is adequate training. Now, those are all points we'll come back to slightly later on. The charter was announced by the UK government in conjunction with a similar charter from the French government, both announced on the same day, funnily enough to coincide with the Maritime Minister's visit to Paris. I think this is quite an important element of the way the charter is meant to operate, is to have those international connections. And perhaps given the importance of the cross-channel maritime links, the choice of France as the first of those was significant. And it was notable perhaps as well that there were a number of operators who attended the launch and essentially supported the charter. That included DFDS, Condor Ferries, Brittany Ferries, and Stena Line, all there, all supporting the introduction of the charter. So as I say, the charter aims to enhance seafarers' rights. The wages part is the legal obligation. The rest is essentially the voluntary standards you have to comply with if you want to apply for verified seafarers charter status. But it's not compulsory otherwise. Quite a lot of the charter is still quite generic in what it sets out to in the standards it sort of sets. So now's the time to look at it in a little bit more detail. This next part is the legal obligation part, and where there is more detail than in most of the other sections of the charter, and that is that seafarers should be entitled to at least the national minimum wage. And this was introduced, the law for this was introduced under the Seafarers Wages Act 2023. Technically, it is now in force, but it hasn't actually started operating just yet. It looks like it will be from 1st June of this year if you look at the draft regulations which are being brought in to implement it. So the fundamental requirement is that UK ship operators must be able to demonstrate that they are paying at least the national minimum wage equivalent to all eligible seafarers in accordance with the conditions set out in the legislation. So the legislation talks about the national minimum wage equivalent. It's not quite the national minimum wage. Partly this depends on things like accommodation offsets and various other complications. The national minimum wage can be quite a technical requirement when it comes to the details. So it is, and it's an equivalent here, given that a lot of the seafarers who use UK ports may not be covered by the ordinary UK legislation. Indeed, probably aren't covered by the ordinary UK legislation, hence the need for the Seafarers Wages Act. So if we break it down and look at the requirements here, the operators, the people who are targeted by the legislation, are those entities who have or have agreed to take on the duties and responsibilities of owners under the Maritime Labour Convention. So they'll be fairly clear who those are. The people who are entitled to this national minimum wage equivalent are eligible seafarers. Now, a seafarer is an eligible seafarer if they are working on ships that use UK ports, irrespective of the seafarer's nationality or the flag of the ship, or any other factors, the law of their contract, for example. That's all irrelevant. It depends on whether they are working on ships that use UK ports. And if they do use UK ports and they form part of a service, then they would be covered if that service calls at UK ports 120 or more times a year. So we need to break that down a bit further. So what's a service? A service is a carriage of goods or people between a place in the UK and a place outside the UK. It is not a single ship. If you are a ferry operator operating a ferry service between France and the UK to keep things simple, and you have 4 ships operating that line, and each does 35 trips backwards and forwards a year, then it is likely that operation will be considered a single service. So although none come to the UK anything like 120 times a year, taken together, the service of the 4 ships does enter UK ports 120 plus times, and therefore the service will be covered. And what that means is that the seafarers on those ships will need to be paid the national minimum wage while working in UK waters. That is going to be maybe between France and the UK. It might not be too complicated, but if it's a longer journey, then it could get quite complicated, because it will be important to have records to show when the seafarers are entitled to UK national minimum wage, and that means you need to have records of when the ship is in UK waters. And so you may find on a journey that if it's from Norway across the North Sea, there'll be a point halfway across the journey that they suddenly become entitled to UK national minimum wage. So you can see that if a service operates between 3 countries or more, that gets quite complicated, and detailed records, as I say, are likely to be required. The government is seeking to establish these what they refer to as minimum wage corridors. So get agreements with each nation on which the service operates across. So as it gets quite complicated, the enforcement of this national minimum wage is enforced by the courts, but the trigger for that is through the harbour authorities in the UK, and each harbour authority is required to essentially ask operators to provide a declaration of compliance if they reasonably believe that a service operated by that operator uses their port 120 or more times a year. Now, the obligation seems to be the way it's operated, going through in the draft regulations, on each harbour authority in relation to the use of its port. So you could foresee situations in which a service operates across multiple UK ports, and the obligation would still be on each harbour operator, rather than a combined UK approach, which might make things a little bit more complicated, or might open up avenues for non-compliance by a ship operator that was looking for the opportunities to do that. So a lot of the time, it is likely that where ferries are operating a regular service, harbour authorities will know whether that service is going to be using their port 120 times a year or not. If it's less than that, they don't need to ask, and probably shouldn't ask, the operator for a declaration of compliance. If it will be 120 or more times, they are required to seek that declaration from the ship operator. It is possible that a harbour authority may mistakenly believe that a service is likely to use the UK port 120 or more times a year, in which case it will have to ask for the declaration of compliance, and having been asked, a ship operator is technically required to produce that declaration. It would seem likely that a ship operator would be able to have a discussion with the harbour authority and seek to convince them that they will not be using, that their service will not be using the port 120 or more times a year. But unless the harbour authority withdraws the request, it will stand. And as I say, the ship operator should produce the declaration, which could lead to some interesting scenarios. The ship operator has to produce the declaration within 28 days. If a ship operator fails to provide the declaration or declares that they're not complying, then there are penalties. Unlimited fines, surcharges on use of the port, and ultimately exclusion from being able to use the port. So the details of those are set out in draft regulations, which haven't yet been finally approved. But it seems pretty clear that it is intended to be put the obligation for primary enforcement on the harbour authorities. But the penalties and the fines would go through the courts. The first part of the consultation closed on the 11th of December last year, and it covered the draft regulations that we've got. The second part, which relates to the surcharges, some of the detail on the equivalent rate of the national minimum wage, that is supposed to be launched early this year. So we expect to see something along those lines very shortly. And yeah, it's important to keep an eye on the consultation papers when they are published, because that will be the opportunity to have some input into what the final legislation looks like. It will be quite interesting to see how this works, and there's the protection of individual seafarers, but also the protection of the UK seafaring business and sector are the primary drivers for this requirement. The next goal, the second point under the Charter, is the paying of overtime at a rate of at least 1.25 times the basic hourly rate. Now, the idea here is that it is obviously that to ensure that seafarers get a bit of extra money for any time they have to spend working more than the basic hours. And under the Charter, that must not exceed 48 hours per week in the UK, which is consistent with the UK working time regulations. Any compensation beyond the basic hours is to be adjusted in line with the national minimum wage as it increases over the years, and is also to be coordinated internationally with other countries. So, for example, the French Charter requires basic hours not to exceed 35 hours, but they have an exception if the law applicable to the seafarer's contract allows a higher number of hours to apply. So in that case, it would appear that the UK 48 hours could still apply, and the French would not have a difficulty with that. The Department for Transport has made it clear that they expect overtime to be paid in, I say cash, but in money, subject to taxes and all the rest of it. But in money, they're not encouraging payment by time off in lieu or equivalent, something along those lines. It is intended to be a monetary remuneration for the seafarer. 1.25 is in general terms a relatively low overtime rate. Many people receive 1.5 or double time. Time and a half or double time is quite a common rate for overtime payments. The third standard, if you like, of the Charter is ensuring that seafarers receive adequate training and development opportunities. Now, this is one of the goals which I think highlights the rather generic and unclear standards being set by the Charter. What is adequate is not really set out by the Charter, even in the more deep guidance. The government and its guidance certainly highlight the support for maritime training, the SMART program, and the apprenticeships, and the Merchant Navy Training Board arrangements. And they also highlight that the government funding is accessible for apprentices, and those sort of things. But it doesn't really go into what is adequate. Safety requirements are all set out in law. That sort of training protection is already there for that purpose. So it's really got to be something more than that. And I think because it does focus not just on essentially basic training, it focuses on development. So there has to be something element of this. If you're an operator going to go for verified seafarers charter status, you're going to have to demonstrate that you are seeking to develop your seafarers. You're giving them career opportunities, support to progress their careers and their own opportunities. But quite what that means, quite what the Department for Transport will expect when they are assessing applications for the status is not, as I say, clearly set out anywhere at the present. Presumably once the whole thing is up and running in more detail, it will become a bit clearer what is required. The fourth goal is that operators have to provide employees with full indefinite contracts to ensure job security. As many of you all know, when indefinite in the UK essentially means not fixed term. So it's what's often referred to as a permanent contract, one that's open-ended, terminal by notice, so it's not permanent as such, but a notice requirement is applied, but it does not have a fixed duration. It's not a fixed term contract. They are very much discouraging the use of voyage contracts for seafarers. There are exceptions. They will be, for example, the guidance talks about where you need to cover a regular crew member's illness for a particular journey. You can hire somebody as a replacement on a voyage contract. But in general terms, voyage contracts are very much discouraged and are likely to be an issue if regularly used for anyone who is seeking seafarers charter status. The full contract really, what it says, it sets out the full set of terms and conditions of employment. So that would be expected to have. And again, this is the idea here is that this applies to any seafarer who is in UK waters, not just UK resident or UK-based seafarers to whom UK employment law would ordinarily apply anyway, because under UK employment law, an employee is entitled to their full contract or full set of terms and conditions at least, regardless, without the requirement under the Charter. So the Charter is intending to extend that protection further. One of the things the contract must provide for is adequate rest, which is a separate goal under the Charter in any event. And it must not charge the seafarers for their accommodation, and it must not make any deductions from earnings for that accommodation. The notice requirements must be at least 7 days to comply with the Maritime Labour Convention, and they must be equal. So the seafarer must be entitled to the same notice from the operator that the seafarer is required to give to the operator. So there are a few more details of what's got to be in that, but it is generally the setting out the full terms and conditions. And some of the next goals we'll talk about will highlight things which you would expect to see in the contract because they are the benefits which come with employment. And in particular, the next slide, some of those. So the things that an operator has to provide to a seafarer include medical care, sickness benefit, old age benefit, employment injury benefit, family benefit, invalidity benefit, survivors benefits, and maternity benefits. Seafarers should also have access to shore-based welfare facilities. The detail of all these benefits, the minimum standard remains a little unclear at present. One of the things which can cause problems is old age benefit, in particular through pension schemes. Certainly in the UK, a pension scheme is heavily linked to tax incentives, in that you get tax relief on your pension contributions from whether they're paid by the employer or the employees. That's one of the big incentives to put money into pensions. Those, you can't, if you're not a UK taxpayer, you can't get those reliefs. And which country should the nationality and the flag of the ship, the nationality of the crew, will may have a big impact on where you arrange your pension cover. If it's expected that the employee is going to go back to their home country, for example, when they're retired, it's going to be important for them, I would have thought, to have a pension that works with their own jurisdiction. And you can certainly see possibilities there for a complication in having crew with multiple nationalities who, ideally from their perspective, would have lots of different pension schemes, old age benefit arrangements. If the UK Seafarers Charter will allow seafarers to opt out of the old age benefit, in the same way that UK employees generally can opt out of auto-enrolment, but the focus is that that's got to be something, a choice of the individual. Employers are not allowed to encourage or persuade or induce employees to opt out. So that may be a factor too. And again, the international partnerships will have an implication here, because France does not allow seafarers to opt out of pension provision. So if you are working between France and the UK, and you have French charter status, you may not be allowed to do that. But there's quite a lot of benefits which may not be provided at present in all cases. The Charter also requires that operators have roster patterns that take into account fatigue, mental health, and safety considerations. Now, to an extent, you would hope that operators already do that. Certainly, you'd want to ensure that safety is complied with and crews are not being worked to the point that they're working unsafely. So, but the Charter again is intended to raise standards. So, in order to show you're meeting this provision of the Charter, it is likely you will have to demonstrate to the Department for Transport that you are doing more than the minimum. So how you adjust roster patterns to take account of fatigue, you're going to have to submit, or sorry, operators are going to have to submit their roster patterns and a risk assessment of those roster patterns to the Department of Transport for a verification that they are at least, say, at least of the minimum level. They talk about the risk assessment should consider optimal, usual, and suboptimal conditions, and explain how they consider these issues will be addressed in cases. So route intensity, fatigue, mental health, safety, welfare, and operational manning are all factors the Department for Transport has indicated will be considered in assessing applications for the status. They are recommending that operators look at their safe manning documents as a source of evidence to show their compliance with this standard. And also the DFT is highlighting the MCA's Wellbeing at Sea tool, which looks at these factors and amongst other things like bullying, harassment and discrimination, diversity and inclusion, physical health, tiredness and fatigue, and organizational support. So it looks like the Department for Transport are going to expect all those things to be addressed and look for evidence that operators are, as I say, at the very least meeting those standards and have measures to address those requirements. As a matter of interest, the is currently conducting independent research on roster patterns, fatigue, safety, and seafarer welfare. And they're saying the current baseline for high intensity routes is 2 weeks on and 2 weeks off. That is what they would expect to see. But they are open to employers agreeing alternative patterns through engagement with local workforce representatives. And they recognize that inevitably there will be a considerable degree of variation between services as to what is required and the level and intensity of those services. As I mentioned, the contract is going to be required to specify rest periods, and they will be expected, what's in the contract will be expected to comply with this next, the 7th point in the Charter, which is to allow sufficient rest periods between shifts and rosters to ensure seafarers can work safely. So the current guidance is that operators must comply with at least the minimum rest periods under the Maritime Labour Convention. So that's the maximum hours of work must not exceed 14 hours in any 24-hour period and 72 hours in any 7-day period. So the balance must be at least, there is a minimum rest period. There are emergency exceptions to those, as you would expect. The operators will also have to have take into account and show how they're addressing ongoing changes to the guidelines from the MCA and also the Merchant Navy Code of Conduct as those develop over the years. But the actual detail as to whether the DFT is going to say that more is required is unclear. But as at the moment, I think compliance with the MLC minimum does look like it may be sufficient on this particular heading. So the 8th requirement is that all crew must receive adequate familiarization training. That must comply with all the existing standards. So, for example, training certification and watchkeeping convention, health and safety under the Maritime Labour Convention, conducted by a competent individual such as a safety officer. And that operators must maintain effective records of such training. If a port or flag finds deficiencies, the employer must rectify this in a timely manner in line with any instructions provided to stay compliant with the Seafarers Charter. That's the guidance we have at the moment. So again, familiarization training. On this one, it doesn't sound like it's going to go a great deal further than the essential recognized minimum standards that exist already. But it will be important for operators to be able to demonstrate this to the UK authorities as well as to their flag state authorities. So that will be a key factor of the Charter and achieving the status. The final heading under the Charter is that drug and alcohol testing must take place at intervals of no more than 12 months. And that must be carried out in accordance with company policy and procedure. So it will be expected to have a company policy and procedure, which the operator can produce to the Department for Transport to show how it's done. It's not in the Charter, but that needs to comply with data protection rules, certainly as far as in the UK and probably in the flag state as well. And there's an expectation that operators will provide support programs for seafarers who may have alcohol or drug dependencies. Now, support can be controversial in certain places. There are times when an operator, a seafarer, is carrying out safety critical duties, but you might say that's most of the time given their roles. So support might well have to take place off vessel on some sort of leave. And then need to get clearance to show that they are in a fit state to resume duties. But there is an expectation that where feasible, support will be provided to seafarers with such dependencies. So this brings us, that's the ninth point on the charter, which takes us on then to the verification regime. Now, as I mentioned at the beginning, there are essentially going to be two statuses. Verified Seafarers Charter, that's somebody an operator who has submitted evidence to the Department for Transport and can demonstrate that they comply with all 9 requirements of the charter. The DFT will maintain a public register of operators that holds the status, as well as of the progressing towards verified seafarers status. The DFT is going to set out a format for producing the evidence that they're looking for. So that will at least be helpful in putting together applications. If there's not sufficient, you could apply for the full status, and if the DFT doesn't regard you as compliant at this stage, they may still award the progressing status as long as they are satisfied that you will be in a position to comply, be fully compliant within 12 months. And during that 12 months, the DFT is intending to have measurable check-in points at regular intervals. For example, the examples they've given are quarterly. And the application can be reviewed at the end, or will be reviewed at the end of 12 months. It could stay as progressing if they're still not satisfied, or if they feel the situation has got worse, then they could remove the progressing towards status as well. The DFT say they're going to involve industry academics or experts to support the review of evidence submitted by operators, although commercial confidentiality would, as you would expect, apply to that. The operators must provide their seafarers with easy access to the charter and the related guidance. And there will be a review of the status annually. So it's not a given that once you have achieved it, you'll be able to retain it for years and years and years. You will have to demonstrate every year that you are meeting the standards. Though you would hope that once you've obtained it, it shouldn't be too difficult to show ongoing compliance. So that's where, well, we kind of where we stand at the moment in terms of there's still quite a lot of detail from regulations to be provided by the Department of Transport, by the UK government. And as I say, there's going to be a consultation this year. Perhaps I should have said, talking about the national minimum wage, the declarations are going to be annual, and that's going to, under the draft regulations, going to apply for the first relevant year, which is intended to start on 1st June. So that's going to be the first operational year of the program. And the idea is that this whole charter will then be reviewed after the first year. So presumably summer, or potentially summer this year, but perhaps more likely summer 2025 when it's actually been in operation. And thereafter every 3 years, and see whether further changes are required to the charter, or perhaps more detail is the thing that strikes me as being the most likely change, rather than fundamental changes to the actual standards themselves, but more detail which would be helpful to operators to know whether they are complying, I think would be useful. So that was really what I had to say on the charter. I am, as Chris said, very happy to take questions and hear your views. I would be fascinated to hear your views on the charter and whether it will achieve its objectives.
Thank you, Mark. Excellent presentation there. A couple of things from my side. Just interesting. I mean, there's nothing in the charter that you would look at and say that's uncontroversial. It's all things that you would hopefully expect responsible companies to have in place already. And with that in mind, I understand the rationale to build it kind of at the UK level, and acknowledging there's France also. But has there been any coordination at the kind of regional level, or probably more importantly for us at IMO, to try and kind of embed some of this? I mean, I know some of the charter proposals are mirroring existing international commitments, but it kind of feels a little bit that we need to try and extend it out in
Underwhelming,
due
possibly, if
course.
there's one word that it might be. Apart from
Mm.
the wages part, I think
Yes, precisely.
you might well say it's yeah. There's nothing there which is a great shock. Um, so and because it's all voluntary, I understand, and I don't know. So you may have more information on this than I do, but I understand there's a lot of discussion going on between countries, but not anything they're sort of really publicizing as yet. And then I suppose if I was
I think
negotiating with countries, that makes sense. You wouldn't blaze it all over the publicity first, but there's lots of
sure.
talk.
I mean, the yes, and it is fair to say the pace of change at IMO is not as quick as we would probably like in a number of areas. So I think there is a lot of benefit to having something at the UK level. What into you mentioned, I think, Mark, early on in the presentation about industry engagement, so the shippers themselves. Do you have any kind of indications at the moment what level of interest, what level of commitment there will be from the industry? Because obviously that's is the key thing that we from the insurance side will look at.
Not really. I think everyone's kind of waiting to see to an extent as
Mm,
to what it actually means, what the further guidance will look like, what the regulations will look like, and to get some steer from the DFT, the Department for Transport, as to what this will actually all mean. And probably nobody wants to be the first one and then get it rejected on some technicality, possibly. And so I'll wait to see if somebody else goes first. But you would expect, given what the government is saying is that they did talk to industry. They were heavily involved in industry in putting forward the charter in the first place, and they did get the backing of some quite large operators when they launched the charter. So I would have expected that there will be an understanding there that these operators will be applying for the status to get it up and running as quickly as possible to get some big names in there.
sure. I suppose the difficulty, as we said, it's so international based. So if you look even at the P&O example, that where it's if I understand it correctly, Dubai owned,
I believe
Dutch
that's right. Yeah.
flagged, it starts to get very complicated about
And that's
trying to
always been
apply
the
those.
problem about applying standards um, to seafarers. And I suppose that's why I suppose the perhaps the novel aspect of the charter is it's not dependent on the flag. It's not dependent on the nationality of the crew. It applies to everybody who uses UK waters beyond a certain minimum threshold. Now, one of the things I suppose I could see changing is the 120 calls a UK port a year. That could be reduced, for example.
Yeah, yeah, it'd be interesting to see how that compliance function works. And do
Mm.
you say it was a DFT who would be running that,
In the
rather than the Coast
background,
Guard? Yeah,
yes, well, it's the harbour authorities who have to seek the declarations, and the
sure.
offence which operators would be, in terms of criminal law, the offence operators could be liable for is a false declaration, essentially, or giving a declaration and then not complying with it. That's an offence. And then the harbour authorities charge surcharges. So that's the mechanism for enforcement on the wage element.
Sure. Uh, I mean, bringing it back to insurance, which is obviously our key angle. We've obviously a lot of this stuff is based around employees and complying with what we would see as basic norms. And so to that end, probably the marine liability policy will be covering off a lot of this stuff already, certainly regulatory compliance. But it'll be interesting to see whether this impacts sort of ship safety. And so when you're looking at things like the rest periods, fatigue, excuse me, picking up basic levels of training, minimum levels of training, and things around there, because that's where I think beyond the liability policy we can start to see some benefits, and it is true to say that in there's now obviously an increased emphasis around ESG issues, and building that into policy discussions and underwriting considerations. So I think here we're pushing against an open door, which is the right thing, really, because these things are what we would see as fairly basic rights to implement. But it'll be as I say, it'll be interesting to see if it can be built into, if it can be measured in some way, in terms of benefit to seafarers, and then a consequent benefit to the shippers themselves, and as a byproduct of that, insurance. And one would hope that the ship owners themselves would see the benefit in applying these. Now, maybe that's a particularly naive way of looking at things, but maybe I'm just naive. So,
I think it might.
do you think it will be? But do you think there will be a kind of that 1 year assessment, 3 year assessment? Do you think there will be a kind of a more kind of in-depth analysis of what the actual practical implication, rather than saying, okay, we've got 5 owners signed up, 5 companies signed up, we want 10? Will there be a bit more granularity around how they assess?
I would like to think so. But I can't speak for government. We've got, there's obviously going to be an election this year, so we'll have a different government by the time a lot of this happens. So it's very difficult to tell what priority will be given to it, what the state of the economy is, where we are. So just to say, my battery, I've just got a message, my battery's about to die. So apologies if I cut out on you, but
That's okay. I think we've come to a more or less an end anyway. So the next step from our point of view, Mark, there's a consultation. When is that due again? Can you just remind me?
The government is supposed to publish proposals from the first consultation, which closed in December. That's likely to happen probably March, April, I would have thought. And the second consultation is supposed to be launched early this year, is what they've said. So I would hope that's going to be pretty soon, because if they are aiming to have the wages part, for example, in place by 1st June, which is the date in the draft regulations, they need to get a move on with those things.
Quite. Well, I think we need to get a move on, Mark, if your battery is going to make it through to the end of the session. So, with that, many thanks to Mark Hamilton at Denton's. As noted, we'll make the recording available, and we will make the slides available. And feel free to contact myself or Mark directly with any questions around the charter. It's something that we will be picking up within our Marine Technical Committee and also within our Marine Claims Committee. So with that, thank you very much for those who are attending online. Keep an eye out for the other market briefings that my colleague Deborah Finch will be circulating periodically, and I wish you all a good day. Thank you very much.
Thank you.
Bye.